Information of the case. Berflu citation, Puncak Niaga Sedia Berhad and another against Syarikat Sidu Adik-Beradik Sedia Berhad and another 2015 8 MLJ 586. The parties is Puncak Niaga Sedia Berhad and Syarikat Sidu Adik-Beradik Sedia Berhad. The case citation is 2015 8 MLJ 586. The court level and location is High Court and Shah Alam. The judges is Suraya Uthman and the judgment date is on 10 January 2014.
Fact of the case. The cause of action under the law of torts in this case is negligence. The issue revolves around whether the defendant breached their duty of care leading to foreseeable harm to the plaintiff. The history of dispute started when a road accident occurred at kilometer 29.2 of the Kuala Lumpur-Karak Highway. The collision involved two oil tankers, one of which is owned by Syarikat Sidu Adik-Beradik Sedia Berhad, the first defendant, and the other by a second unnamed defendant. The collision between the two oil tankers resulted in a significant spill of crude palm oil, which later seeped into the highway's drainage system and subsequently contaminated Sungai Gombak. Since Puncak Niaga Sedia Berhad, the first plaintiff, is responsible for operating the Gombak water treatment plant, Sungai Gombak plays an important role as a water catchment region. Syabas, the second plaintiff, distribute the treated water from Puncak Niaga to the consumer. Sungai Gombak's protection is mandated under the Environmental Quality, Sewage and Industrial Effluents Regulation 1979, which declare it as a water catchment area. This is to guarantee the safety and purity of raw water applied for public delivery by designating specific region as a water catchment zones. In the trial court, plaintiffs Puncak Niaga and Syabas sought special damages for the cost of cleaning up the contaminated site, including personal costs, chemical costs, loss of income, and other related costs. In its defense, the first defendant made allegations denying liability, including the plaintiff's failure to take precaution and was unaware of the water catchment area along the highway. The defendant, on the other hand, did not provide documents to prove their claim, which raised doubts about the damage suffered by the plaintiff. At the same time, the court awarded nominal damages to the plaintiff based on the principle that nominal damages can be awarded even without precise proof of special damages, if it can be reasonably assumed that the plaintiff suffered damage due to the defendant's violation. Each party's legal claims and defenses centered on the question of negligence and who was ultimately responsible for what damages resulted from the spill. The trial court found that the collision and the ensuing contamination were entirely the fault of the first defendant, who was found to be 100% culpable. The court held that the first defendant accountable for the pollution of the river and water intake, taking into the account the likelihood of contamination arising from the oil spill.
So there are 5 issues for this case. First, whether the contamination of pollution of the river Sungai Gombak and the Gombak intake located at kilometer 28 of the Kuala Lumpur-Karak Highway was a result of the spillage of crude palm oil onto the highway due to the collision of the defendant's tankers at kilometer 29.27. Second, it is whether the first defendant solely negligent 100% liable or whether the second defendant equally negligent and liable for the collision. If so, at what percentage? Next, whether the oil spillage onto the highway due to the collision would result in the contamination or pollution of the river Sungai Gombak and the Gombak intake was reasonably foreseeable or whether it could be reasonably foreseen by the defendant. The fourth issue is whether Puncak Niaga is considered negligent for not taking any steps to prevent contamination or pollution of Sungai Gombak and the Gombak intake by putting up warning notices or signages to inform the public of the presence of water catchment area at Sungai Gombak at kilometer 28 of the highway. The last issue is what is the quantum of damages suffered by the plaintiffs as a result if the defendant were negligent in causing contamination or pollution of Sungai Gombak in the Gombak intake.
Okay, so next we're going to be talking about contentions by both parties. I will be touching on the subject of contentions by plaintiff or the appellant. Alright, first and foremost, the plaintiffs were represented by Ms. Shanti Subramaniam, assisted by Mr. Adrian C. Juhong and Ms. Nur Ain Kamaruzaman. Okay, among the submissions made by them was number 1, the careless action of the first defendant's driver slamming into the rear of the second defendant's tanker, damaging the tanker in the process, caused the spillage of the crude palm oil from the highway, contaminating Sungai Gombak and the Gombak intake subsequently. So what this means is that the first defendant's driver actually bumped into the second defendant's tanker, causing the tanker that was filled with crude palm oil to spill and contaminate Sungai Gombak at the same time. Right? So the second one is that Aware that carrying crude palm oil in their tankers onto the highway would be hazardous if spilled, the defendants at the time of the accident were owed a duty of care as road users. Okay, so the defendants at the time, especially the defendant who was driving the tanker, they are aware that the tanker containing the crude oil, especially the crude oil itself, is hazardous if it was spilled. So when they are carrying the tanker, they are automatically owed a duty of care in order to ensure that the crude oil is not being able to spill. So once it's spilled, they know that it will be hazardous. Okay. The third point I want to mention here for the contentions is that the statutory duty inflicted by law, a duty of care, was bestowed upon the defendants to the plaintiffs who are dependent on the water catchment area as their mode of business, which was gazetted as such within 29.2 kilometers from where the accident occurred. So the plaintiffs here had a business around a water catchment area that was just 29.2 kilometers away from where the accident and the contamination occurred. So the defendants were given or were inflicted a duty of care because they did not aware themselves around the surroundings and made sure that nothing else were going to be damaged along the way. So they are owed a duty of care. Alright, so the fourth one is the defendants should have predicted that the plaintiffs would suffer losses and be equipped with expenses had the water catchment area incurred contamination from the oil spills due to their negligence, resulting in the defendants being charged with statutory duty as well as a duty of care. So in here, it has mentioned that the defendant should already predict that the plaintiffs would actually suffer losses because the plaintiff mode of business, their main mode of business is within the area of the water catchment area. So if the water catchment area is already contaminated, so they won't have any mode of business and they won't be able to generate cash. So if they are not able to generate cash, they won't have a business to run. So therefore, the defendants at the time should have already predicted that the plaintiff at the time would suffer losses prior to the oil spillage. Okay, and so they were inflicted with duty of care and also statutory duty. And last but not least, the public is subject to prior notice of the existence of the water catchment area as it has been gazetted. Hence, the losses suffered by the plaintiff for the contamination of the area by means of oil spillage due to negligence is predictable. As mentioned here, the public was already aware that there was such thing as an existence of the water catchment area. So there was no room for the defendant to not know that there was a water catchment area there and that the plaintiff was using the water catchment area as a mode for his or her business. So therefore, it is negligent of the defendant in that moment to not be aware of that, and also the fact that the plaintiff would suffer the losses is predictable. So that is all from me. I will pass it on to my partner next. Thank you.
Contentions by defendant or respondent. The first defendant was represented by Mr. Vignesh Selvanathan, assisted by Mr. Saifuddin Shahrudin. Among the submissions made by them are, the first defendant was not the only factor in the collision. Other contributing factors included the sudden stop of the second defendant's vehicle and state of the road at the relevant moment, which saw only one of the three lanes open to traffic because of construction work being done by the highway management. The second argument is, in order to alert drivers to the presence of a water catchment area alongside the highway, Puchaniaga had neglected to place any signs or signage along the route. The first defendant was unaware that the water catchment area along the roadway existed. Therefore, there was no duty of care owed by the first defendant to the plaintiffs because it was not reasonable to expect that the oil spill from the collision could contaminate the water catchment area and cause the plaintiffs to incur costs and lose out on the opportunities. The third argument is, additionally, Puchaniaga had neglected to put in place any safety measures to stop pollution or contamination from oil spills into Sungai Gombak. Puchaniaga ought to have been informed and taken preventative action to ensure that a similar incidence of oil pollution in Sungai Gombak didn't happen again, as it had happened in 2002 as a result of a highway accident. And lastly, the plaintiffs are not entitled to a duty of care from the first defendant, only other drivers on the roadway are.
Today, I would like to talk about judgment by the court. The court determined that the defendant's tanker collision did cause the crude palm oil to flow onto the highway, contaminating Sungai Gombak and the Gombak intake. The judgment was supported by the data that was provided, which shows a clear causal connection between the collision, the oil leak and the water contamination. The first defendant was found to be 100% culpable for the collision due to his total negligence. It was observed that the first defendant's driver, which is Muhammad Rusli, ought to have driven more cautiously at the scene of the collision because there were road construction project underway along the route at the time. Due to carelessness on the part of the first defendant, the collision happened when their tankers crashed into the back of the second defendant's trucks. The court determined that the defendant had a reasonable expectation that the collision-related oil spill onto the highway would contaminate Sungai Gombak and the Gombak intake. The conditions surrounding the collision and the distance between the oil spill and the water source contributed to this predictability. The The court addressed whether Puncak Niaga, the first plaintiff, was negligent in not taking measure to prevent contamination of the Sungai Gombak and the Gombak intake. It was found that Puncak Niaga had fulfilled its duty by gazetting Sungai Gombak as a water catchment area and that publication in the official Gazette Warta Kerajaan PUA 12 Jil 23 number 3 as a water catchment area under the 4th schedule of the Environmental Quality, which is Sewage and Industrial Effluents Regulation 1979 under the Environmental Quality Act 1974. Plaintiff 3 constituted sufficient notice. However, the court rejected the defense that the first defendant lacked knowledge of the water catchment area, stating that the ignorance of the law is not a valid defense. Moreover, the plaintiff experienced losses because of the careless action of the driver working for the first defendant. The driver caused a crash with another driver, which is the second defendant, who was driving a tanker truck. As a result of the crash, the crude palm oil that both tankers were carrying spilled onto the road and then flow into the drainage system, eventually ending up in a Sungai Gombak and the Gombak intake. This is because the first defendant had duty of care towards plaintiff, which they breached by causing a collision resulting in a oil spillage. The spillage contaminated the Gombak river and the intake, leading to losses for the plaintiffs who relied on a river for their business. Consequently, the first defendant was held fully responsible for the damages suffered by the plaintiff. Puncak Niaga was accused of being partially responsible for an accident because they didn't have any sign warning drivers about the water catchment area or any safety measures to prevent oil spills on the highway. However, the court decided that the Puncak Niaga wasn't at fault because it was actually the first defendant's careless action that caused the collision and the spill. So, the first defendant was solely responsible for the contamination. In this case, the court ruled that Puncak Niaga was not guilty of contributory negligence because the main cause of accident was the first defendant's action, not anything that Puncak Niaga did. First of all, contributory negligence means both parties are partially at fault, but in this situation, the court found that only the first defendant was to blame. Therefore, Puncak Niaga and Shabas was seeking compensation for damages in the court. However, they were not able to provide enough evidence to support their claims for specific damages. Even though they couldn't prove the exact amount for their loss, the court still decided to award them some money as a symbolic gesture. This is called nominal damages. Puncak Niaga was awarded 50,000 ringgit and Shabas was awarded 75,000 ringgit. This shows that even if you approve exactly how much you lost, you may still receive some compensation in certain situations. Thank you.
Yeah, now talking about the ratio descendenda of the case of Puncak Niaga, Malaysia Sdn Bhd, and another versus Syarikat Siddu Adik Beradik, Sendirian Berhad, and another. Now there are 5 issues actually. There were 5 issues surrounding this case as canvassed by parties during trial, and the court's findings on these 5 issues essentially form the descendenda of this entire matter. Now the first issue is, was contamination of Sungai Gombak due to the weather. The contamination of Sungai Gombak was due to the collision of defendants' tankers. Now regarding this issue, there is no dispute on this matter. And the second issue was of the liability for the accident. Now the court found that the first defendant to be 100% liable, because the tanker driver should have been more careful, more so knowing that there were road works being carried on in that area. Now the third issue was that the defendant claimed ignorance of the catchment area, as there were no specific notices put up by the plaintiffs regarding the same, or regarding which part. There was no demarcation, there was nothing, no notices saying that that is a catchment area. So that was the argument by the defendant. The court held that the ignorance of law is no bliss, it's not an excuse, that means. And the effect of the Gazette is to place a duty of care, as in the case of Abdul Aziz bin Muhammad Alias versus Timbalan Ketua Polis Negara, Malaysia, and another. Now, the fourth issue here was whether there was a contributory negligence on the part of the plaintiff for failing to take adequate measures, measures to prevent the contamination of Sungai Gombak. And this is more so because there was a similar incident happened some time back. Now, the court held, regarding this issue, the court held that the first defendant was solely responsible and, in fact, 100% liable for the sufferings and losses of, or the losses incurred by the plaintiffs. Now, the final and fifth issue of this matter is on the claim for special damages by the plaintiffs. The court held that since there were no specific documentary proof, or there was an absence of specific documentary proof to substantiate such claims, then there was no reason for the court to award special damages and could only be awarded, and the plaintiffs could only be awarded nominal damages, as in the case of Guan Sun Tin Mining Company versus Wong Fuk Tam. So that was the ratio designated for the case of, as mentioned before, the case of Puncak Niaga Malaysia Sendirian Berhad and another versus Syarikat Siddu Adik Beradik Sendirian Berhad and another. Thank you.
So for the commentary part, I agree with the court's decision based on this case. Special damages are meant to make up for losses that have a monetary value attached to them, suffered due to the breach. It is important to provide clear evidence to support claims for damages, as demonstrated by the court's nominal damages award, despite the plaintiff's inability to prove their claims for special damages. The case we can relate here is Overseas Tankship UK Limited and Mott's Dock and Engineering Company Limited, the Wagon Mount, held that a defendant is only liable for damages resulting from their carelessness that was reasonably foreseeable. The Puncak Niaga case resonates with this principle by focusing on whether it was reasonably foreseeable that negligent driving leading to an oil spill would contaminate the water supply. Contributory negligence is a tort rule that bars plaintiff from recovering for the negligence of others if they were too negligent in causing harm. The allegation that Puncak Niaga was contributory negligent for not putting preventive measures like signage in place was rejected, supporting the idea that people whose careless actions caused the injury are primarily responsible. This idea prevents victims from paying for the negligent party's action. In the case of Tan Ah Kau and Tan Ah Wah, where the court held that the driver was negligent because he failed to keep a proper lookout and drove too fast. Due to his driver's carelessness, the defendant, which is the employer, was held vicariously accountable. In both cases, it was decided that the defendants were vicariously liable for the carelessness of their driving. Statutory duty is a law that a company, a government organisation, or the members of a particular profession must obey. Public notices are issued by a government agency or legislative body in certain rulemaking proceedings. The public was required to refrain from polluting Sungai Gombak once it was designated as a water catchment area and published in the official gazette. The court believes that not knowing the law is not an excuse, even if people say they didn't know about the water catchment status. As mentioned in paragraph 30b, the first defendant did not know of the existence of the water catchment area along the highway, but the defendant still owed a duty of care in this case. As we can see in the case of Rylance and Fletcher, the plaintiff's property experienced flooding caused defendant's careless construction of a reservoir. The decision established the rule that a landowner who stores potentially dangerous materials on their property in a way that puts others at risk is strictly accountable for any harm done should those materials escape. This case is relevant because it clarifies the idea of strict liability, which is comparable to what happened in Sungai Gombak. Regardless of whether they knew about the law or meant to cause harm, anyone who contaminates a legally protected water catchment region may be held strictly accountable for the damages. For conclusion, this case emphasizes how crucial it is to understand and follow national rules, especially when driving a car. Knowing these laws aids in defending your rights. Furthermore, driving cautiously is essential to lowering the danger of accidents and saving lives on city streets or highways. In this instance, the defendants and others' safety was jeopardized due to the truck incident and the ensuing oil leak into the water catchment area. The court's ruling in this case of Puncak Niaga Sendirian Berhad and another, and Syarikat Siddu Adik Beradik Sendirian Berhad and another, emphasizes the importance of taking careful steps to prevent harm. It proved that the plaintiffs might sue tort law remedies where their negligence resulted in damages. The plaintiff claimed Puncak Niaga was negligent by neglecting to put precautionary measures in place, like posting signs, designating a water catchment area. A precedent for the high level of care necessary to guard against carelessness and duty violation is established by this case. Additionally, it highlights the legal duty to refrain from careless behavior and the substantial influence of tort law on relation legal practice. This highlights the interaction between contract and tort law.